Losing a loved one is undeniably one of life's most challenging experiences. Amidst the profound grief, discovering that you have been named an executor adds a heavy weight of responsibility to an already overwhelming time. You are suddenly tasked with managing an estate, settling debts, and distributing assets. But what happens if something goes wrong? Today, we are discussing executor liability, and when you could be held personally responsible for mistakes made while managing an estate. Please note, this video is for informational purposes only and is not legal advice. Always consult with a qualified legal professional for specific guidance. At the heart of an executor's role is a fiduciary duty. This is the highest standard of legal care. You are legally bound to act solely in the best interests of the estate and its beneficiaries, setting aside your own personal interests. This responsibility is built on 4 core pillars. The duty of loyalty means you cannot profit from your position. The duty of care requires managing assets prudently. The duty of impartiality dictates treating all beneficiaries equally. And the duty to account means keeping accurate records of every transaction. Failing to uphold these duties through misconduct or negligence is where personal liability begins. If your actions cause a financial loss, you can be held personally responsible for replacing those funds. As an executor, you are bound by a strict fiduciary duty. When you breach this duty, even through an honest, unintentional mistake, you open the door to personal liability. If your actions or failures to act cause financial harm to the estate, you could be forced to pay out of your own pocket. As an executor, your primary duty is to protect the estate's assets. Mishandling them is the quickest way to face personal liability. Take negligence, for example. If an estate property is left uninsured and suffers damage, or sits abandoned and loses value, you could be held financially responsible. Another major pitfall is commingling funds. This happens when you mix estate money with your personal bank accounts. Even with perfect records, courts view this as a strict breach of fiduciary duty. Estate funds must remain entirely separate. You are also responsible for smart management, making highly speculative investments that cause massive losses or allowing physical assets to deteriorate, legally known as waste, violates the prudent investor rule. Finally, the most severe violation is theft or embezzlement. Borrowing estate money, taking unauthorized fees, or removing items before probate is finished guarantees strict personal liability and potential criminal charges. As an executor, one of your primary duties is settling the estate's debts before distributing anything to the heirs. If you hand out assets to beneficiaries while creditors are still owed money, you could be held personally liable for those unpaid debts. Taxes are another major pitfall. The IRS and state tax agencies expect the final income tax returns and the estate tax returns to be filed on time. If you miss these crucial deadlines, the estate faces hefty penalties and interest. And here is the real danger. If the estate runs out of money because of these penalties, or because you paid the wrong debts first, creditors and the IRS can come after your personal bank account to cover the difference. It is essential to keep track of every bill and tax form. Our third scenario is a major red flag: self-dealing and conflicts of interest. As an executor, you have a strict fiduciary duty to put the estate's interests above your own. You cannot use your position to personally profit. For example, what if the estate includes a vintage car or an undervalued house, and you decide to buy it yourself? Purchasing estate assets at a discount or without explicit permission from the court and beneficiaries is a direct conflict of interest. The same rule applies to hiring services. You cannot hire your own company or overpay family members for estate work like cleaning or repairs. Any transaction that enriches you or your close relatives at the expense of the estate can make you personally liable for the financial damages. Another major pitfall for executors is the improper distribution of assets. This often happens when a will is ambiguous or poorly written, leaving the executor guessing about who gets what. If there isn't a will, varying state intestacy laws dictate the distribution. Making a mistake here or failing to properly locate all rightful heirs can make you personally liable for the misdirected funds. Finally, never distribute assets to beneficiaries before all estate debts and taxes are fully paid. If the estate runs out of money to pay creditors because you paid the heirs first, those debts might come straight out of your own pocket. As an executor, you have a fiduciary duty to keep meticulous records of every penny entering or leaving the estate. Failing to maintain clear accounting is a serious breach of your responsibilities. Beneficiaries have a legal right to request a formal accounting. If you present them with confusing spreadsheets or missing documents, they can petition the court to hold you personally liable for unaccounted funds. Even honest bookkeeping mistakes can lead to accusations of mismanagement. In extreme cases, poor record-keeping can be treated as fraudulent accounting, resulting in severe financial penalties ordered by a judge. How can you protect yourself from personal liability while serving as an executor? First, never hesitate to seek professional help. Hiring an experienced probate attorney or a tax professional provides a vital layer of protection. The estate typically covers these fees, and their expert guidance ensures you comply with complex legal deadlines and court requirements. Second, document everything. Keep a meticulously organized spreadsheet tracking every estate transaction, email, and decision you make. Transparency is your absolute best defense against beneficiary disputes. Keep all heirs informed through regular meetings, and before making final distributions, always have them sign a beneficiary release form. Finally, look into specific insurance options. You can often purchase executor liability insurance, which covers your legal defense costs in the event of a lawsuit. You might also secure an executor's bond, which acts as a safety net, protecting both the estate and your personal assets from honest mistakes. With these actionable precautions, you can serve confidently. Let's look at 3 real-world examples of executor liability. In the first case, an executor sold an estate property far below market value. The beneficiary successfully sued, and the executor was held personally liable for the lost value. In our second example, an executor commingled estate funds with their personal accounts. Although they planned to repay the money, the court demanded full repayment plus steep punitive damages. Finally, imagine an executor who distributed the estate's assets to the heirs before paying off a known creditor. That executor was served a court summons and forced to pay the outstanding debt out of pocket. Quick FAQs. An executor is named in a will, whereas an administrator is court-appointed. Can a beneficiary be the executor? Yes, provided they remain impartial. How long does settling take? Typically 9 months to several years. Being an executor is a major responsibility. Always consult a qualified estate attorney to guide your decisions and protect yourself from personal liability. Serving as an executor is a profound responsibility, but it doesn't have to be a liability. By staying organized, communicating clearly, and seeking professional legal advice, you can navigate the probate process with confidence. If you found this helpful, please like, share, and subscribe. Have questions? Drop a comment below or visit us at probateus.com to get the expert guidance you need today. Thanks for watching.